It's Friday also. Ooh, all right. Good afternoon, everyone. Welcome to the Government Labor and Elections Committee. This is our vote list number 3. Today is Friday, February 27th. We have several bills on our list this afternoon. I'll begin with our vice chair presenting on HB 262.
Madam Chair, HB 262 is the Council for Open Data. The Senate did attach some amendments. The Department of Information Technology agrees to those amendments, so I would like to move the amendments.
Okay. Is there any discussion on the amendments?
I move the bill as amended.
Oh, we have to adopt the amendments first.
Oh, sorry.
I learned this from last week. Yes. All right. Seeing no discussion on the amendments, all in favor of the amendments signify by saying aye.
Aye.
Opposed? All right. Seeing that the amendments have passed,
Now, Madam Chair, I would like to move the bill as amended.
is there any discussion on the bill as amended? 262. All right. Double checked. It's 262. Seeing none, roll call.
Vice Chair Kerr,
Yes.
Delegate Sample Hughes,
Yes.
Delegate Lehman,
Yes.
Delegate Ruth,
Yes.
Delegate Klippinger, Delegate Terraza,
Yes.
Delegate Schindler,
Yes.
Delegate Chisholm,
Yes.
Delegate Siliberti,
Yes.
Delegate Wu, Delegate Schmidt, Delegate Fisher,
No.
Delegate Stewart,
Yes.
Delegate Tomlinson, Delegate Wilson, Delegate Fair,
Yes.
Delegate Solomon, Delegate Crutchfield. Motion passes.
What about me?
Oh,
I vote yes.
Madam Chair.
Don't vote? All right, we'll move on to our next bill, Delegate Kerr.
This is the Military Family Inclusion Act, which changes the composition of the board. It has already, believe, crossed over from the Senate, and there are no amendments. I move the bill.
Is there any discussion on, oh wait, we need to say, thank you. Is there any discussion on the bill? Seeing none, roll call.
Motion favorable, House Bill 270. Vice Chair Kerr,
Yes.
Delegate Sample Hughes,
Yes.
Delegate Lehman,
Yes.
Delegate Ruth,
Yes.
Delegate Klippinger,
Aye.
Delegate Terraza,
Yes.
Delegate Schindler,
Yes.
Delegate Chisholm,
Yes.
Delegate Siliberti,
Yes.
Delegate Wu,
Yes.
Delegate Schmidt, Delegate Fisher,
Yes.
Delegate Stewart,
Yes.
Delegate Tomlinson,
Yes.
Delegate Wilson,
Yes.
Delegate Fair,
Yes.
Delegate Solomon, Delegate
Yes.
Crutchfield. Motion passes.
HB 300, Delegate Kerr.
HB 300, State Contracts Prohibited Provisions, has crossed over from the Senate. There are no amendments. I move the bill.
Any discussion? Okay, seeing none. Bills move favorably.
Motion favorable, House Bill 300. Vice Chair Kerr,
Yes.
Delegate Sample Hughes,
Yes.
Delegate Lehman,
Yes.
Delegate Ruth,
Yes.
Delegate Klippinger,
Yes.
Delegate Terraza,
Yes.
Delegate Schindler,
Yes.
Delegate Chisholm,
Yes.
Delegate Siliberti, Delegate Wu,
Yes.
Delegate Schmidt, Delegate Fisher,
Yeah.
Delegate Stewart,
Yes.
Delegate Tomlinson,
Yes.
Delegate Wilson,
Yes.
Delegate Fair,
Yes.
Delegate Solomon, Delegate Crutchfield.
Yes.
Motion passes.
Delegate, presenting HB 364, Delegate Kerr.
Oh, got it. This is State Veteran Cemeteries. There was an amendment in the Senate that was adopted by the Senate and sent over here. I checked with the House sponsor, Delegate Kipke, who agrees with the Senate's amendment. So I will move the amendment.
Any discussion on the amendment?
Can I just ask
Yep.
what the amendment does?
Yeah, it defines internment.
I'm sorry?
It defines internment. The
That was
original,
the bill, the amendment, just, there was a typo and one instance of the word inurnment was left out.
Is it technical?
Yeah, purely technical.
Technical? That's fine.
All right. Seeing no further discussion on amendments, is there a motion to move, oh, wait, excuse me. All in favor of the amendments, aye. Aye. Okay, seeing that, and none opposed, seeing that the amendments have been adopted, is there a motion to move the bill as amended?
move the bill as amended.
Okay, any discussion on the bill as amended? Okay, seeing that HB 364 has been properly amended and moved and accepted, roll call.
Motion favorable with amendment, House Bill 364. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Yes.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
Yes.
Delegate Ciliberti.
Yes.
Delegate Wu.
Yeah.
Delegate Schmidt.
Yes.
Delegate Fisher.
Yes.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes.
Motion passes.
All right, and apologies, I skipped over a bill, HB 301. Delegate Kerr.
Thank you, Madam Chair. This is the Maryland Military Department supervision of state active duty personnel. This only applies to Section 32 scenarios under which the state active duty National Guard are federalized but are still under the governor acting as commander-in-chief. It does not apply to the Maryland Defense Force or state operations. It passed the Senate and has crossed over with no amendments. I move the bill. Oh, there is, excuse me, there is an amendment. Can you explain the amendment, please, Tyler?
It just makes it an emergency bill.
Oh. I move the amendment.
Is there any discussion on the amendment? Seeing none, all in favor of? So many cooks in the kitchen, I like this. It's helpful. So now, wait, I lost my train of thought.
You do that.
The motion to adopt the amendment has already been passed. So all in favor of adopting the amendments, aye? Aye. Okay, seeing that, no opposed. Motion to move the bill as amended.
I move the bill as amended.
Okay, discussion on the bill as amended. Seeing none, we will do a roll call on adopting the HB 301 favorable with amendments. Excuse me, thank you.
HB 301, the motion is favorable with amendment. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Sure.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
Yes.
Delegate Ciliberti.
Yes.
Delegate Wu.
Yeah.
Delegate Schmidt.
Yes.
Delegate Fisher.
Yeah.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes. It's not.
Motion passes.
Presenting. So next bill presented is HB 553, Delegate Kerr.
Thank you, Madam Chair. Delegate, HB 553 is the highly controversial elevator certificate bill that has passed the Senate, has crossed over to the House. There are no amendments. I move the bill.
Okay. Properly moved. We'll do a roll call on favorable motion for HB 553.
HB 553, the motion is favorable. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yeah.
Delegate Ruth.
Yeah.
Delegate Klippinger. Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
No.
Delegate Ciliberti.
No.
Delegate Wu.
Yes.
Delegate Schmidt.
Yes.
Delegate Fisher.
I'm down on this one.
Delegate Stewart.
He laughed at his own joke though, so.
I'm up on this one.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes.
Motion passes.
Okay, all right. Moving along to labor. We have HB 536, and Delegate Stewart is presenting.
Thank you.
amendments.
Thank you, Madam Chair. House Bill 536 received a favorable with amendments report from the Labor Subcommittee. The amendment is, there is one amendment and it's technical. Move the amendment.
Any discussion on the amendment? Seeing none? Okay, all in favor of, oh, wait.
It's technical.
Okay.
Trust him. Yeah, you trust him, right. Nothing to worry about.
Seeing
constitutional.
no
have a
discussion.
42-page
No, no, I have a
Oh, okay, Delegate Terraza has a question.
You said it's technical, but does it, I'm just skimming, it looks like it defines related medical condition?
And it is technical. So basically, in various parts of the bill, it has to change pregnancy and then add or another related medical condition under this section. In the original draft of the bill, the drafters just neglected to add that phrase in one specific section where they had throughout the rest of the statute. So it just adds it in one place that was left out. So
Oh, adds
it's
the
technical.
definition there. Okay.
It's extremely technical. You can trust me.
Tomlinson, is your light on unintentionally? Okay, yes, Tomlinson.
Thank you, Madam Chair.
On the amendment?
Oh, no,
Yeah,
sorry.
let's adopt the
for the
amendment.
bill.
Yeah.
You're doing great.
It's Friday.
All right, all in favor of adopting the technical amendment? Aye.
Aye.
Opposed? All right, seeing that, is there a motion to move the bill as amended?
So moved.
Thank you. Discussion? Delegate Tomlinson?
Thank you, Madam Chair. So the only letter of unfavorable testimony came from Carroll County's Chamber of Commerce, conveniently enough. So and thank you, Delegate Ruth, for helping for trying to help me out with this. And I know you referenced some of your remarks back during the committee hearing. Can you just walk me through, if we go through like a scenario here, a woman's going through menopause, she goes to her boss and says, I'm having some issues here. I mean, what are we expecting is going to happen?
Yeah, totally. Happy to do that for you. In fact, we could almost get into the same camera. We could just, so right now in Maryland, there is a reasonable accommodations process for people who have complications from pregnancy and people who have complications from surgeries. So if you've had some sort of surgery, let's say you tore your Achilles or you have some complications from pregnancy, you can go to your employer and kick off what's called the reasonable accommodations process. So here's how it would work. If the bill passes, we'll use your example with menopause, because the bill adds menopause to that list of pregnancy and also childbirth to the list. So right now, and if the bill passes up with menopause, how it works is a woman goes to her employer, says, I'm having some issues with hot flashes or some other complication of menopause, and it starts an interactive process where the two basically try to work out what a reasonable accommodation for that employee would look like. And the employer has to grant the reasonable accommodation unless there is an undue hardship on the business, which is existing law. That's how it works in the ADA. And so if there's a hardship on the business and the hardship is relative to the size and the scale and the resources of the business, then if there's an undue hardship, they don't have to grant it. So how it would basically work is, let's say a woman is having complications from menopause. She goes to her employer and says, hey, I need to take off the next 3 weeks because I'm having hot flashes. Well, clearly the employer would say, no, that's an undue hardship. I can't have my employee gone for 3 weeks, or I need to leave at 3 p.m. every day. The employer is going to say, no, that's not reasonable. That's an undue hardship for me. I need you to work. That is not proportionate. But if the woman says, hey, could you turn the thermostat down to 67 instead of 72, then they can work out perhaps through an interactive process that maybe 69 or 70 degrees works rather than 72. So essentially, this process already exists for childbirth. For pregnancy, this just adds childbirth and menopause to an existing process that employers are already familiar with, and that generally involves very minor accommodations, because if there's an undue hardship on the business, they don't have to do anything at all.
Delegate Fish, oh. Your question's been answered, Delegate Tomlinson?
Yes.
Okay. Delegate Fisher, your question.
Oh, yeah, I was just commenting on the bill. One of the comments that we had in regulation of businesses was stacking of benefits, where the benefits just keep stacking and stacking and overlapping. So we have FMLA, PWFA, PDA at the federal level. And then we have the Maryland Healthy Working Families Act for paid sick leave. And certainly this would apply for that. Okay, so we already have laws for this, guys. There's also the forthcoming family program, right? Maryland Family and Medical Leave Insurance Program that was intentionally delayed by the governor and the Secretary of Labor for the sole purpose of waiting until after the election because it's so incredibly burdensome and difficult for businesses, particularly small businesses and medium-sized businesses to implement. But nonetheless, the protections that are alleged in this particular bill are already covered by existing law. And so its intent is to stack and to create new ways of suing rather than just saying, you're not feeling well, take off, which is, in my mind, what my daughters would do. The two daughters that I raised, they would say, well, of course they would, because it'd say, I'm not feeling well, I'm going to take off and take leave. So, and I think that's we can laugh, but it's kind of common sense. And the stacking of these benefits doesn't help people I think on either side because the benefits are stacked so highly at this particular point. So that's why I'm going to vote no, because the right to have leave already exists in all of these circumstances and to be paid at the same time. Thank you.
Delegate Wilson.
Thank you, Madam Chair. I guess I just have a question or two. So the childbirth, unlike pregnancy, I guess I'm trying to find out, I'm sure there's a definition. We kind of all know what childbirth means. Is this complications after childbirth?
Yes.
But they already take their FMLA and all that stuff. And then when they come back, they still have complications.
Yeah.
How is childbirth or complications from childbirth at that point any different than a medical issue? Because it is a medical issue. Right, so why are we redefining childbirth when it's already in the statute because it's indeed a medical issue?
Exactly.
Right now, the only things that are provided are pregnancy-related and surgeries.
Under the ADA?
Mm-hmm. Yes, and under our state analog.
So if I have pancreatic cancer, if I have some sickness, I believe I'm still already covered by our ADA.
You can ask for a reasonable accommodation for an illness, but that's different than a temporary disability due to the laundry list here. It's a separate process. Yes, if you're undergoing chemo or whatever, that's considered a disability. These are actually not considered like permanent disabilities. This is the temporary disability section of the statute.
Well, even if you get into a car accident and you have a backache or a back injury, a temporary back injury, that's also covered already.
Yes.
So I don't understand. I guess I just don't understand why. I worry that we're doing something that may complicate things because anything after childbirth would be considered a medical issue, which would already be covered. And so, again, when we start this process, you put words in that may be unnecessary, that could have unnecessary complications. Secondly, when we're talking about menopause, I guess, in a prior life, I had my committee staff person, my lead one, she was going through menopause at the time. Oh, at the time. Sorry about that, Joe. I didn't know you were here. And no, so my question is, how is it that, again, so would the accommodation mean I have to buy her a heater and a fan?
No.
But you said about...
So to be clear, the reasonable accommodation process requires absolutely nothing of employers in a strict sense. There is a process where the two talk and they figure out what is reasonable and what's not reasonable. And so nothing strictly is required. I gave an example of maybe turning the thermostat down would be a reasonable accommodation, but No one's required to do that under the bill.
And again, but as you well know, and the reason we're putting this in the statute is because if indeed they don't feel that they have, their employers met the burden, then they will get the Department of Labor involved, and depending on how this is set up, they can also sue civilly. So again, when we become very nebulous in what the issues are, then the solutions may also be nebulous, therefore expensive. And I guess that was my concern. So menopause has a variety of symptoms, I guess, and I just didn't know how that's supposed to apply to an employer, because again, it's very case by case. Again, like buying a fan may be what would be required or demanded. In fact, you'll know because a lot of young ladies that are no longer young walk around with these fans. And I'm again asking this question. I apologize, Madam Chair. I'm asking this question, could somebody get sued because they're like, absolutely not, I'm not gonna, number one, I'm not turning the air down because there's 80 other people in here, or 4, and 2, I'm not gonna buy you a fan. Are they now opening themselves up for a suit by the Department of Labor? And I'll say this from one of my experiences, the Department of Labor sometimes has a hair trigger as far as how they move forward. Because that's why I just wondered why these were included, why these were overall necessary, because I thought we had most of these, like with disabilities due to childbirth. Well, disabilities is already covered. In fact, by you just using the word disabilities, it becomes redundant, anything after that.
Okay, so a couple things. Appreciate those comments. So first of all, we do not want to make complications from childbirth, and we do not want to make menopause a disability. You're right that disabilities are already protected. This is a temporary, this is what's called in the statute a temporary disability. What Maryland and what the ADA already says is that if you have a temporary disability from being pregnant, then you can go through this reasonable accommodation process.
Right.
This is an expansion, and this was not currently protected by law because the temporary disability list is exactly one thing. It's pregnancy. And so if you have a temporary disability from something else, namely menopause under the bill and childbirth under the bill, you now get those same protections that are afforded to women who have temporary disabilities stemming from pregnancy.
So,
But to answer your question about are people going to get sued if they refuse to give out fans or whatever, the answer is that, as you know better than probably everyone in this room, people, when you open up new avenues for people to file lawsuits, the answer is always going to be yes, people can get sued. That doesn't mean they're going to be successful. And generally, the Department of Labor, you say they have a hair trigger. You, as the former chair of that committee, know more about that issue than me. But people don't like to file lawsuits and lose generally. I think it would be a not meritorious lawsuit to try to sue someone for declining a fan in that situation. Because as long as the employer has a reason why they're not granting the request, namely that it's an undue hardship on them because there are other people in the office, like you said, or any of these other things, those would basically be a bar to the lawsuit.
and Madam, I don't want to belabor this, Madam Chair, but again, when you have a Department of Labor investigation, it isn't just narrowly tailored. It is a book opening thing. It costs hundreds of thousands of dollars, if not more, to defend, even if it's not meritorious. And again, this is one of those things where that's not the only employee that's questioned. They then begin questioning other employees, and they're looking at it really opens the books up. As soon as investigations started, we've heard the AG come in time and time again, talk about the importance of opening the books to our employers. So that was my concern, because it actually says disabilities due to childbirth in the title, ergo disabilities. And again, the menopause thing being very nebulous, my concern really is what are we opening up here? Or what is it we're trying to do that's not yet been done? So are we saying that there have been complaints because these things have not been taken care of?
Yeah. So.
Can we get counsel? Yeah, can we actually, I would like for counsel, I'm going to let the subcommittee chair talk as well, but I do want counsel to respond to some of the questions that the delegate raised.
I just wanted to offer a point of clarification. The bill covers childbirth, menopause or related medical condition. Specifically to the related medical condition, it's for lactation and then any duration or effects of like vasomotor symptoms to menopause. So it's not the duration of childbirth, the duration of pregnancy. I just want to offer that point of clarification. Thank you.
Delegate Ruth.
Thank you so much, Madam Chair, and Council pretty much said what I was going to say. It's not all of META flashes. And to Delegate Fisher's point, the accommodations for these, you're talking about people taking off of work, but this is less than having somebody take off of work. An employer can negotiate a fan to be put on the floor or something, as opposed to what you're talking about is people taking off an entire day from work every time they have a hot flash, and that just would not be what we would want. And so, this is supposed to be minimal. I mean, it's the reason why this is necessary, even if we already define disability and health conditions, is that historically women's health concerns are discounted. And these types of things, like hot flashes, many employers will just shrug their shoulders because, oh, she's just having some hot flashes. It's not a big deal. But for the woman experiencing it, it is a big deal.
Thank you. Delegate Fisher.
Thanks. Yeah, I would just say, and I appreciate that. So the family program, again, has not been implemented yet by the Department of Labor, and they're trying to do that. So what this bill is doing is, in many ways, duplicating something. And I know you're making the argument, someone is at work and something happens. And again, I have to defer to the two daughters that I've raised with my wife, who would simply go home and take the day off, or maybe the week off, or longer. And that is to me, that is what a person would do. And I do think that the purpose of the bill, and I'm not saying the sponsor wants this, but I think the ultimate end thing of the bill will be to potentially result in lawsuits against the employer, when all you're trying to do is to say, you should definitely take off, you're not feeling well, and take leave, or whatever the policies are of the company, but you also have the protections that the state has provided, some of which aren't even yet implemented. So we're kind of getting ahead of ourselves with the bill. That's all that I'm saying. And please, and I'm just going to say this, please don't do the woman-man thing, because my wife and I raised two children, so I want to caution you from that, because we never did that in ECM. We always talked about things. I'm just saying that because sometimes I sense that, that bills are put in to virtue signal rather than the fact that we already have accommodations in law that allow for people to take off long periods of time to get well. And those are things, generally speaking, that I think we all support. So.
Okay, one thing, because there's people in the queue. Delegate Crutchfield.
Thank you, Madam Chair. I just wanted to mention a couple of things in response to Delegate Fisher, and also to you as well, Delegate Ruth. I think one of the things we need to recognize is that ADA mentions a lot of different medical conditions. However, it's not explicit when it comes to menopause and other related conditions resulting from childbirth and other, female, male kinds of specific issues. So that's one thing to recognize. The other thing is that in most cases, I would say employers will look to ADA. They'll also look to specifically around pregnancy protection, all of those things. And you're absolutely correct. A lot of this falls into different holes, okay? However, recognize it's not going to be stacked in Maryland, okay? There are some other jurisdictions that stack on. In Maryland, it will be running concurrent, all right? So ADA issues, you'll talk about those. You'll do what Delegate Stewart mentioned, which is you go through the interactive process, you find out what works for people, and then you come to some conclusion. Now, the other part with that is that, of course, if it does not, or if the business cannot handle it, and it becomes burdensome, or if it's, through a business necessity that they cannot do it, then they won't be able to do it. I mean, if someone asks for $10,000 equipment to be put in their office, that may be burdensome to a small business, okay? So just thinking out of the box on that. But I think, again, just recognize that these are not specifically designated in the ADA and specifically designated in any kind of laws,
again, when we go to pregnancy laws, childbirth, none of that specifically talks about these particular issues. So just recognize that. And again, stacking does not happen in Maryland, okay?
Delegate Terraza, and then Delegate Ruth.
Thank you, Madam Chair. I just wanted to point out that the symptoms of menopause can last more than a few days or a week. So it's not really an issue of taking off time. Menopause can last several years. And the needs along that process might change. And so I'm just not sure how I see taking off time as like responsive to this at all.
Delegate Wilson and then Delegate Stewart.
Brief question for the attorney. Is there anything so far in any of our legislation that has accommodations for, and excuse me for asking, but I do have 3 daughters and a wife, so for women on their monthly cycle?
It's my understanding that we don't.
Right. Now, I'm saying that in preview, it's what's coming, I guess, next year. Because again, is this different than that? Something that's, as far as accommodations, I don't know, because obviously I've never gone through menopause. And is that a likely outcome of what we're doing now? And that's not for you, that's like, don't worry, I'm not trying to put you there. That's, again, my concern is, again, the overall, every time we put something in statute, make sure you understand this is a Department of Labor issue now. And can and will be enforced through the Department of Labor and through suits and investigations. But that's another concern I have, and maybe that's a legitimate bill for next year. I don't know, because it's not what I deal with. But again, I just see the direction this is possibly going.
The one thing I will say, it came up in conversation about PCOS, which I can't remember the full acronym, which typically does lead to, one of the things that can lead to really excruciating menstruation. So that's not included in this bill, however. And that would be probably an example that would, because not all menstruation leads to the need for time off, but there are related conditions that do have a significant impact on menstruation. But that would be under ADA.
That was almost my point. That's fine, because that's exactly where I was going with it.
Yeah.
Thank you. Yeah.
Delegate Stewart, I'm going to call on Delegate Sample Hughes first, if you don't mind.
Sure. Thank you, Madam Chair. This is just real briefly, but just knowledge purposes, but a hot flash doesn't warrant you to have to go home. Like, I could have had 2 of them sitting here right now and then and still be sitting here smiling and talking to you all day long, but I've already had 2, right? And then the other thing, I would say some of the other symptoms like inflammation. It's hard to keep up with that. My hands are red a lot, but I still work. So I didn't need to go home. I just wanted to bring that clarity into the picture. But there certainly are, just like other members have stated, there are long-term effects, such as mental health and issues that happen with menopause. So just be mindful of that. As some temporary stuff goes on, you may get up, walk outside, get a cold with the air, and you come back and work. So just FYI. Thank you, Madam Chair.
Delegate Stewart.
Thank you, Madam Chair. Just a couple quick clarifying points. So first of all, I think I misstated it earlier probably, but this is actually not under the Department of Labor's purview. They don't sue under this. This is MCCR. So this would only be MCCR, Maryland Commission on Civil Rights, because it's employment discrimination.
Is this creating a protected class?
No. No, it's not, does not create a protected class. But MCCR has the jurisdiction, and I just tried to quickly look up how many actions they've brought under the existing authority they have for temporary disability related to pregnancy, and it's very limited. So I don't think that they're going on sort of these massive litigation, runs here and filling up the court. This is a totally different class of people than people who take leave. I mean, these are people who can work and they want to work and their employers want them to work. They just need a small accommodation. So if someone has to be out for 90 days or whatever and they cannot work, I'm glad that there will be leave policy available for them at the state level, and thanks to those in the room who are involved with that. But this is a totally different category of person with a condition that allows them to stay on the job, which is what everyone wants. They continue to earn income. They continue to get promoted. Their employer wants them there. They have that institutional knowledge, et cetera, et cetera. If people can work, they should work. We shouldn't be pushing them into leave policies. And then I was also going to make the point that Delegate Terraza made, which is that this is different than some sort of temporary condition where you take 90 days off and then you're back and you're ready to roll. This can be something that is a relatively minor condition that you've had for many, many years that would far outstrip whatever leave is available for you on federal and state law. So yeah, with that, I'll shut them.
Okay. All right, seeing no more discussion on the bill as amended, and we had a proper, did we have, okay, just, so we had really robust discussion. Okay. Seeing that, we will do a roll call on the motion to move HB 536 favorable with amendments.
The motion on House Bill 536 is favorable with amendments. Vice Chair Kerr.
Yes.
Delegate Sample Hughes. Yes. Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Yeah.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
No.
Delegate Siliberti.
Yes.
Delegate Wu.
Yes.
Delegate Schmidt.
Yes.
Delegate Fisher.
No.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Delegate Sample Hughes, yes. I said for you.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes.
Motion passes.
Okay, all right, thank you. Moving on to HB 182, Delegate Fair is presenting.
Thank you, Madam Chair. House Bill 182 prevents faithless electors from casting the state's presidential electoral votes against the will of the voters. Specifically, the bill requires electors to pledge to cast their votes for the candidate of the political party that nominated them. If an elector violates their pledge, they are considered to have vacated their office and are immediately replaced by a substitute elector. There are amendments on the bill. The amendments make various technical and clarifying changes, including correcting cross-references to federal law and requiring the state administrator of elections to serve as the secretary at a meeting of the electors. I move the amendments, Madam Chair.
Second.
Oh, no, so, okay, seeing no discussion on the amendments, all in favor of adopting the amendment, say aye. Aye. Any opposed? All right, is there, now the amendments have passed, is there an amendment to move the bill as amended, excuse me?
Move favorable as amended.
Okay, any discussion on the bill as amended? Seeing none, we have a motion to move the bill favorable with amendments for HB 182. Roll call.
HB 182, the motion is favorable with amendments. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Yeah.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
Yes.
Delegate Siliberti.
Yes.
Delegate Wu.
Yes.
Delegate Schmidt.
Yes.
Delegate Fisher.
Yes.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes.
Motion passes.
All right, thank you very much. HB 621, Delegate Fair will be presenting again.
Thank you. House Bill 621, the bill repeals the requirement that the council to a local board of elections be a resident of the county and instead requires that they be a resident of the state. There are no amendments to the bill. I move the bill favorable.
Is there any discussion? Delegate Wu.
Thank you, Madam Chair. I have a question for the committee.
Yeah, go ahead.
Committee chair. So I'm thinking about a situation when people from maybe out of state, like Maryland, they want to apply for this position. So is this possible under this condition?
No, so the current rule says you have to actually live in the county to be the counsel to the board. What we're saying is that you have to live in the state, so
Yeah.
nobody from out of state can apply.
So it makes it broader, right? And makes sense as well. I think my question is like, it doesn't make sense that we're not allowing out-of-state people to apply.
Correct. Yeah, and that's a good thing that because there's certain state regulations, state laws. You want somebody familiar with the state that's living in the state.
But like second one, you admit to practice law in the state, right? Because a registered voter, you have to be the people live in the state. So my point is like, can we say that after you accept the offer, you need to be like a state resident or registered voter instead of like immediately to be a registered voter there?
Yeah, so right now it says that you have to live in the county in order just to get the role. So we're actually expanding it and saying now, okay, we don't require you to live in the county, we just simply require you to live in the state.
I see. Can we make it broader?
I would suggest that we don't, because again, there's people that, in every state, there's specific laws, and especially around election law. You want people who are familiar with those state laws and very familiar and able to get on the ground running. These cases get very technical and very complex. You really don't want somebody coming from out of state to suddenly start weighing in on the state election law.
Thank you.
No, thank you.
Okay, seeing that there is no further questions on the bill, we have a motion to move HB 621 favorable. Roll call.
The motion is favorable on House Bill 621. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Yes.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
Yes.
Delegate Silberti.
Yes.
Delegate Wu.
Yes.
Delegate Schmidt.
Yes.
Delegate Fisher.
No.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
Yes.
Motion passes.
Thank you very much. All right, moving on to our last bill, HB 855.
Thank you, Madam Chair. House Bill 855 extends the period of time during which a common ownership community must allow political signs to be displayed from 30 days before an election to 45 days before the start of early voting. There are no amendments to the bill. Move favorable.
Any discussion? Seeing none, HB 855 has been properly moved favorably. Roll call.
The motion is favorable on House Bill 855. Vice Chair Kerr.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Lehman.
Yes.
Delegate Ruth.
Yes.
Delegate Klippinger.
Yes.
Delegate Terraza.
Yes.
Delegate Schindler.
Yes.
Delegate Chisholm.
Yes.
Delegate Silberti.
Yes.
Delegate Wu.
Yes.
Delegate Schmidt.
Yes.
Delegate Fisher.
Yes.
Delegate Stewart.
Yes.
Delegate Tomlinson.
Yes.
Delegate Wilson.
Yes.
Delegate Fair.
Yes.
Delegate Solomon. Delegate Crutchfield.
All right, yes, Delegate Schmidt.
Thank you, Chair. Can I be recorded in the green for House Bill 262, House Bill 270, and House Bill 300, please?
Time for,
Yes. Schmidt in the green, House Bill 262, House Bill 270, and House Bill 300, please.
do you guys have that, staff? Yes. Okay, just want to make sure. All right. All right, with that, we are adjourned. Have a good weekend, everyone.
I guess I didn't put it in writing, but I.
Which bill was that? I think I just maybe, yeah, I went off the vote list. That's what it was.